Hey folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. And today again we are continuing with the prevention of operation and mismanagement. And hopefully this is gonna be one of the last lectures of this chapter, right? Maybe I'll have one more lecture that will be a very small one. If we are not able to cover the powers, right, in this lecture, then we'll have a small lecture for discussing those powers. Otherwise, most probably we'll be completing the entire chapter in this lecture. So one more chapter comes to an end for you, right? So yeah, don't be very happy. It's not yet over. We need to go through this lecture. So what do we discuss today? What are the topics left in this chapter? Yes. So we are going to discuss about the appointment of directors by the central government, which is section 408. Now, appointment of director by central government. There's a confusion. Normally, if you go through this section for the first time, what confuses us is who is appointing, CLB or CG. As the heading says, yes, they are appointed by the central government. But yeah, even company law board has a good role to play over there. So let us go ahead with the understanding of the section one by one with the provisions to understand what role has CLB to play in this scenario. Right? So basically section 408, it is empowering the central government to appoint what? Directors, right? So who are these directors that the central government appoints? If you refer back to the director chapter, right, those directors who are appointed by central government or any other financial institutions, right, that it be necessary, they are all termed as nominee directors. Do you remember that? We have already discussed it in the lecture previously. So this section empowers the central government to appoint nominee directors on the board of the directors of the company, right? But when does the central government do so? Is it its discretion that today, yeah, let me do one thing, let me go ahead and appoint a nominee director? No, the central government does not go to all the company to appoint all nominee directors over there. So what is the situation? When does that happen? It only happens if an order is made by the company law board. So basically, when the company law board asks the central government to appoint a nominee director, then it is the responsibility of the central government to go ahead and appoint a nominee director. They'll choose who will be the director. So ultimately, yes, the appointment of these directors are being made by the central government, but it is only being made after receiving an order from the company law board for such appointment. Right? If a nominee director needs to be appointed, first it comes from the company law board and then it comes from the central government. So first we'll see the
Effect.
effect of 408, right? So this is the
Effect.
and now who is making the application? So if you talk about any reference or any application to the company law board, it has to be made. Why? Because the company law board also will not come up suo moto with a power, right, to just order the appointment of an interim director. It has no suo moto power to make any inquiry and pass any order for appointment, right? For this special situation, we have given enough power to the CLB in the previous sections that we have discussed, right? If you remember the last lecture, they had enough power. Immense. Amend the article, amend the memorandum, go against the Companies Act, whatever you want to do. Ultimately, the operation and mismanagement had to be tackled, right? But over here, what they want is additional director. That is a nominee one, right? A nominee director needs to be appointed. So for that, what they need is they need a reference. So first, either it is referred by the central government that listen, company law board, I think this company, they need a nominee director because of certain situations that have taken place. Maybe the board is dissolved, all of a sudden directors all resigned. Maybe somebody ran away without somebody absconding, without even knowing what is happening and what's not. The company is out of control. Somebody needs to take care of the company. Who will that be? That will be another director who will be sent by the central government. So the company law board can make that application only when if a reference has been received by the central government, or it is not only the central government who can give that reference, right? An application for the same can also be made by not less than 100 members of the company. When I talk of 100 members, I'm talking in terms of numbers. On the other hand, it can also be made by members who are holding not less than 1/10 of the total voting power of the company. If you go back to section 399, they talked about 1/10 of the issued share capital, not the paid up or anything, 1/10 of issued. So there's a difference between what you have issued, there's a difference between what is paid up, and there is a difference between the total voting power. So don't go by the layman on the first page saying, okay, 100 and 110, it is the same as 399. No, it is not the same as 399. That talks about issued capital, this talks about voting power. And there's one more term, paid up capital, which is not talked about in any of these sections. Now, when we talk about the power of the central government to make that reference, right, what do you think? What are the powers given to them? Do you think that only when there's a case of operation or mismanagement, and just to tackle that operation mismanagement, central government comes up to say, "Hey, listen, there is some operation, some mismanagement going on in the company. We need to tackle that. We are the defense force. Let us send a director. Let us send our warrior." No, no, no. Nothing of that sort is necessarily required. Yes, that also happens. But that is not a precondition for central government to make their application. Getting the point? There should be some reason and some valid reason where the central government thinks that no, there is a requirement of a nominee director. They're not able to handle the company, or there is something wrong going on. Somebody needs to catch hold of those things. And that is not only in the case of operation and mismanagement that you have complained and then they think, no, nobody has complained. But CG noticed that something is going wrong. Right? So this is actually a power given to central government which is administrative in nature. Right? So CG is behaving like an admin department of the same company. So the only requirement is that there should be a valid material before central government for making the reference. Possession of any sufficient evidence of any gross mismanagement or operation is not a precondition. Same has also been referred to a case. If you go back and get to the case of the Skipper Construction Company Private Limited versus the Union of India 1992, you get that. Over there also there was no precondition of operation mismanagement. But they went ahead with doing that. I'll also discuss a case with you, right? Maybe in this lecture or the next lecture, I'll discuss a case where the central government actually went ahead to appoint that nominee director or to make an application to CLB, then CLB gave an order and it was mad. So what are the scenarios that will be clear in that case? Right, I'll come to that. Maybe 10 minutes down the line, I'll narrate that entire case with you. Right, one has to be discussed for an understanding. You don't have to mug up the case. Always remember, the name that I just took, the Skipper Construction Private Limited versus the Union of India, you don't need to mug that up. That is why it is not printed on the screen over there. If I wanted you to mug it up, I would have written that on the screen so that your visual, your auditory, all the sense organs would be active to receive that. Right? You understand the power? And in this case, there is no opportunity of being heard given to the company. So the company is not entitled to be heard in this situation. Okay? Now, what does CG do? CG makes a reference to the company law board. The 100 members are making reference to the company law board. The 1/10 of the total voting power are making reference to the company law board. So the company law board will come ahead and make an inquiry. Right? So company law board will establish an inquiry. But only when the reference has been received. So whatever inquiry the company law board thinks fit in this situation, the company law board goes ahead to make that inquiry. Now there are certain essential conditions for making orders. The order that the CLB is making, there are certain essential conditions for that. Right? So the CLB will actually go ahead and make an order in this favor, in this regard, only when it is satisfied of basically two conditions. Right? The first one says that, okay, yeah, on the first hand, on the face of it, we can see that the affairs of the company are not being conducted in a proper manner. They are being conducted in a manner which is prejudicial to any member of the company or to the interest of the entire company, or if not of any of those two, it is prejudicial to the interest of the public in general. So prejudicial to any member, the company, public, whatever it is, that is a valid condition for company law board to go ahead and set up an inquiry. And when that inquiry is set up, the result will determine whether they will pass on an order to the central government to make a nomination or not, or make an appointment or not in that case. The second condition is to see if such order is necessary. Is it necessary to make an appointment of those people? Maybe one nominee director, maybe more than one nominee director. Right? Is it necessary for what purpose? So as to prevent the current state of affairs of the company. Right? So they understand as per what the members or what the government has said, when CLB went ahead with the inquiry, they just thought that is it necessary to appoint someone else to prevent this current state of affair? Or can it be prevented without even appointing that person? There is some other easy remedy out of it. If there is some other in-house remedy, CLB may follow that. But if they think that no, a person is required, CLB will ask the CG, the central government, to go ahead and make that appointment, right? So first thing was to see if the state of affairs are managed properly. Second is to safeguard the interest of the members, right? The interest of the public, the interest of the company. To safeguard that, if the company law board deems it fit to appoint, then they would order it to the central government to appoint that person. Okay with that? Getting the point? And the nature of orders of the company law board. The company law board is coming forward to make an order. So what are the nature of the orders? There are basically two categories, right? Once the inquiry is completed by the company law board, they have to make an order, right? The order can be an alternative of the two. First is the order for appointment of a director by CG. Second is an order for adoption of a proportional representation. So it is not only the central government who would be allowed to appoint, even by proportional representation they can be appointed. So what happens for the order of appointment of directors by the CG? So if that has been made, right, so the company law board may order appointment of certain number of directors. When I say certain number, that means there may be a situation that one nominee director cannot actually go ahead to fulfill the requirement, right? So they need more than one. So even more than one directors can be appointed. That is clear with you, right? So once the company law board has made an order to the central government, then central government may appoint the director as they deem fit, or as it has been specified by the order of the company law board, right? And these directors whom the central government are now appointing into the board of that company, who is holding the position of a nominee director, they will hold that position for next 3 years and try to resolve whatever has gone wrong. They are basically the protector of the public interest of the company, or the interest of the member in general, right? So they are there for that purpose. So if they solve that purpose, 3 years is a good time for that. So it is given to them, and then their appointment will not remain valid. They'll have to vacate the office. But if in 3 years they're not able to get the company back to the same situation as it should have been, then they may also be granted another year of 3. If after 3 years the situation is remaining constant, they can be given another 3 years of the time to make that amendment. It's only if the same condition is persisting, and that has already happened with the case. So if you understand the case of Urban Improvement Company Private Limited, right? This is what had happened in that case. Okay. Next is appointment or adoption of proportional representation. So you all know what proportional representation is. Section 163 has been dealt with in detail when we were discussing the director chapter. If you are still confused with that, go back to section 163 and read and understand that lecture again, and then you will have a bit more clarity on this, right? I will not spend a lot of time going and explaining what proportional representation is, right? So the company law board may direct the company itself that, listen, you need to appoint certain directors, right? Now they are not nominee directors. These are directors appointed by the company, but they'll be appointed on the basis of proportional representation, right? So this direction has been given to the company by the company law board, right? And that proportional representation will exactly be as per section 163 of the New Companies Act, right? And once the company receives such a direction, they are bound to make necessary amendments in their article, right? And then make fresh appointment as per proportional representation, right? In the article, they have to insert the clause that they'll be appointed directors on the basis of proportional representation, and the number of directors will go up and all those things, right? And then they will make an appointment on the basis of proportional representation, and that will be done within the time frame which has been specified by the company law board. And then the company law board may also further order a certain number of additional directors to be appointed into the board of directors. And once that order has been made by the company law board, right, then the central government may appoint the additional director, right? And that will also be based on the order that has been given by the company law board, right? And this additional director shall now hold the office until new directors are appointed on the basis of the proportional representation. So what happened, if we look at the entire scenario, there was a reference made to the company law board from either the central government or 100 members or 1/10 of the total voting power. Company law board made an inquiry. Company law board saw that, okay, there are certain situations according to which we will have to send somebody in, right? Then what did company law board do? Company law board made an order to the central government, please go and appoint somebody to rescue the company from the situation where they are in. Central government appoints somebody, that person is there for 3 years. If things do not turn well in 3 years, that person is there for next 3 years. On the contrary, what the company law board can do is that they go to that company itself and say, listen, use a proportional representation, amend your article and appoint somebody. But it is difficult for the company to appoint it at that point of time because there is already mismanagement. So if they're not able to appoint somebody by proportional representation, so for filling up that gap of that duration that they're taking to appoint somebody into that position as a director, right, by a proportional representation, then that gap will be filled up by the central government temporarily. And as soon as somebody is elected or somebody is taken up as a director as per the proportional representation, then the additional director that had been taking that position from or on behalf of the central government will now be vacating the office. The rest of the topic will be taken up. See, if I show you the rest topics are these four things. But I think I'll take them up in the next lecture. Right? But even then, before closing this lecture, I would narrate that case with you. Remember I talked to you about the incident, about a case study? So when we are talking about the satisfaction of the company law board, there are certain parameters that the company law board will also check. There must be certain evidence, sufficient evidence, and the proof which ordinarily satisfies an unprejudicial mind beyond a reasonable doubt. So you understand the words that are used in the law. If there's a person, right, who is not prejudicial or prejudiced to against anything, so that mind has to be satisfied beyond reasonable doubt or objectivity. Well, if you can do that, it's okay. Just if there's a mere formation of an opinion, that opinion will not lead to all these activation of section 408. Right? There should be sufficient cause and sufficient doubt has to be raised. Right? So if you look at the Secretary to the Government of India versus the Lifen India Limited, right? So this section was activated in that case, right? And central government was actually empowered to appoint an additional director or more than one additional director, sufficient number of additional directors, nominee directors, right? To safeguard the public interest. What actually happened in that company was that the company had collected over 15 crores from 6,000 depositors, but it failed to repay it back on time. And then there has been systematic diversion of these funds through various subsidiaries and other concerned companies. Then there were some major assets of the company which was disposed of at throwaway prices. And after doing all these, the managing director was absconding. And the other directors who were there in the board, they retired or they resigned. Listen, I don't want to be a part of this, I'm resigning. So all of a sudden the company went for a toss and the managing director was absconding and the directors went on after giving their papers, that is the resignation papers, and they vacate the office. Now what will be the condition of the company? Any one or two directors who are even remaining at that point of time will not have the courage to take the company forward. Right? What do? That is when they apply or they make an application to the company law board. And that will not be made by those directors, it will be made by those members. Right? So the members know that the company is going for a toss, will go for a loss. They approach the company law board. Hey, company law board, listen, we need some help. Right? And then they make an application. The company law board gets into the case to understand, makes an inquiry. If satisfied, gives order either to them to use the proportional representation concept as per 163 or orders the company law board to immediately send some nominee directors or orders both of them that you arrange for somebody via proportional representation. In the meantime, there will be additional directors sent by the central government. So this is the entire scenario. Got the point? Are you comfortable with the topic of appointment of directors by CG? I guess yes. Right? So let's do one thing. Let's end this lecture over here and not keep it too lengthy. And the other remaining topics, these two topics, we'll be taking up in the next lecture. And also the power of the CLB to prevent changes in the board. The entire section will be taken up in the next lecture. Right? And that is the last one is section 409. And then the chapter comes to an end. Okay? So I'll see you guys back in the next lecture. Until then, this is Abhinay Gupta signing off. Thank you and bye-bye.